022-0388DE. All right, we are here for a pretrial today on this case. May I have the names of our participants, and let's begin in the courtroom. Your names, please.
My name is Karen McKean.
Would you spell that for us, please?
McKeen.
And how is Karen spelled?
Karen. Thank you.
Daniel Kotcher.
All right, do you have that one? All right. Okay, let's go to whoever's logged in. Mr. Zawida?
Zawida, Judge. Robert Zawida on behalf of Stanley Kotcher.
Russell Smith, Your Honor, on behalf of Karen McKean and Daniel Kotcher, who are in the courtroom with you.
Good afternoon, Your Honor. Austin Probst, also on behalf of Stanley Kotcher.
Yeah. And we have a Nicholas. Go ahead.
Yes, Your Honor. Nicholas Kotcher.
And Your Honor, my client wanted me to convey that he apologizes for not being able to appear today. He is in the United Kingdom celebrating his daughter's graduation from a master's program, and he couldn't make it happen. So he apologizes for that.
Well, that's all right. He has you to be here for him, to speak for him, and pass along congratulations.
Thank you.
All right, gentlemen, this was a final pretrial conference that was scheduled back in December. We would have been looking for some trial briefs and some binders and exhibits in anticipation of a trial. It was also scheduled, a trial scheduled in February. So I have not received any of those documents, so I'm looking forward to what's been happening and why maybe that I haven't received anything yet. So who wants to go first?
Well, Judge, I'm sorry, go ahead.
No, that's fine. I was just going to indicate, Judge, that since we last appeared in court, Mr. Zawida and I have exchanged substantial communications regarding a possible resolution of the matter. Only recently has it broken down to the point that the settlement appears to be impossible, but we're still holding out hope. Now, this went on until probably yesterday, actually, and
5 minutes ago.
yeah, pretty much. And I spoke to Mr. Zawida, and it's our joint request if the court could give us an additional week to provide those documents, it would be wonderful. We did not, either one of us, want to put in the time and effort to prepare the substantial documentation if there was one iota of a chance of resolution, Judge. So that would, I think, be our joint request.
And I would also like to suggest, Judge, I know we have a trial date scheduled. It's a bench trial scheduled for the 12th and the 13th. If at all possible, I would like to ask for a short adjournment of that, another week, if at all possible, to accommodate the fact that we're pushing back the deadline for the trial briefs and the joint exhibits as well. I'd like to give the court additional time. And I will state for the record that I probably drank more Kool-Aid than I have in my entire lifetime, and I believe the Lions will win the Super Bowl the day before.
Well, that's optimistic.
It is.
Very good. So if we're going to move the trial, then I would probably also reset our final pretrial. And the next day and a half that I would have available to you would not be until March 11th and 12th.
I might have an arbitration that day. I'm looking at my calendar, Judge. Just
please do.
I could go either the 19th or the 20th or the 25th.
Yeah, it's not going to work that way. I can give you what my calendar is available, but I'm not going to be able to look for your dates on my. It's not going to work that way. So if you can't make the 11th and 12th work, then your next available date would be Wednesday the 20th all day and Thursday the 21st until 11.
Judge, speaking for Mr. Kotcher and Ms. McKeon, I would be, I was agreeable to a short delay, but I would ask the court to keep the trial dates as they are. This case has been pending for a long period of time. So it's totally your call, Your Honor.
Well, my docket's extraordinarily busy, so if you want an adjournment, those are the available dates.
I can't, my clients would literally be appalled if I agreed to it, Judge. I did talk to Mr. Zoida about a short adjournment, which I would not have been opposed to, and I understand the busyness of the court. I would ask the court to keep the same court dates. I think it's the 12th at 9, I believe, and also the 13th at 1, as it now stands. 12th.
I would still, I'm sorry, go ahead, Judge.
That's okay. The 13th is now available in the morning as well as in the afternoon if we need 2 days. One of the questions a couple of things that I wanted to ask the two of you is, number one, do you think that mediation could be beneficial if you think there's a possible resolution? And number two, I would also be happy to meet with you in chambers, and if there's a couple of issues that you wanted to discuss with me to assist you in negotiating, I'd be happy to do that as well. It's up to you.
Judge, the case has been mediated a number of times. Phil Shadler with Southeast Michigan Dispute Resolution mediated it twice. We actually made some movement during the last mediation, but it didn't get done. Given the stance of the parties, I do not believe additional mediation would be fruitful. I do believe that an in-chamber conference with Your Honor would be very beneficial to the lawyers as far as several things we need to discuss procedurally.
I would agree, Judge. I agree with counsel. And in terms of mediation, we did make a lot of progress the last time, but I think we hit a wall. We did work hard over the past week, which is why we didn't submit anything today, because we could have avoided expending more of our respective clients' money. It seemed like a good idea. But I think it wouldn't hurt for counsel to speak privately with Your Honor if the court will so allow.
Sure, we can take a brief recess to allow for that. I'm going to check in with my 2 o'clock hearing, or I'm sorry, the 1:30 that was scheduled, because they were running a bit